Good afternoon, everyone. I'd like to welcome everyone to our Ethics Continuing Legal Education program, dealing with unfavorable information about your client or case. I'm Jim Sheldon, and with me is Dinah Straube. We're both from Neighborhood Legal Services. We work in the Disability Law Unit. And we'd like to thank the Volunteer Lawyers Program, VLP, for their co-sponsorship of this particular session. Hopefully everybody signed in the back. When you leave, you have to sign out again. That's one of the New York State requirements for getting CLE credits. And I'd like to also thank Penny Somansky and Karen Welch, who initially organized it, and then we had to find some dates that would work out for presenters and so forth. Quick summary of some logistics. We're going to go for about 90 minutes. We started about 5 after 12. We'll end as closely as 1 to 1:30 as we can. We have to get in 75 minutes of actual delivery time. Those who are attorneys, you're going to get 1.5 CLE credits in the ethics category. Now there's 3 handouts that you should have picked up at the back table where you signed in. The thicker one is the training outline, and that's the one that we're going to be more or less walking through sequentially in the first half of the presentation. Then about midway through we're going to turn to this hypothetical, which is 2 pages, and there's a printout of the 4-page PowerPoint. We'll bring up slides 3 and 4 when we go into the hypothetical, so that you're forced to think about the rules. Just a couple of other things before I turn it over to Diana. This session is being videotaped, and I'm going to remind Diana that when we have questions from the crowd, we want to encourage questions, that we'll repeat them so that they get picked up on the videotape. If this works, VLP is going to put this on a YouTube channel so that people can view it after the fact and get CLE credits that way. Again, we'll walk through the outline. I want to encourage your questions. What we really want to do through the hypothetical and your discussion is really try to come to grips with the classic dilemma that occurs when you've got unfavorable information. And what you're going to be dealing with, and we'll get into this throughout the presentation, is 2 kind of conflicting principles. One, Rule 1.6, which we'll go into in a little bit of detail, about the confidentiality of information that comes to you as an attorney or a paralegal working under attorney supervision. And then Rule 3.3, candor towards the tribunal, your obligation, and we'll go into when it applies, to make sure that you correct anything that comes up that's wrong, your obligation not to present false testimony. So let me turn it over to Diana to go through just a little brief history of some of the ethics rules as they apply.
Well, good afternoon. I'm going to try to stay in one place because otherwise, it's going to catch part of my top of my head and my nose. And what are ethical codes? Well, they're essentially the legal community policing itself. That's what they are. And in New York, you can find them. I think they're in 22 NYCRR Part 1200. And the preamble to New York's ethics specifically states that they weren't intended to create causes of action. What they are, again, is the legal profession policing itself, and it can result in disciplinary action if rules are violated, so including suspension, disbarment. So it's not intended that you're going to be able to be sued for this, for a violation, but you could end up sanctioned or disciplined if you violate an ethical rule. So therefore, it's incumbent on us to know what's expected, and that's not always an easy thing. Sometimes it is. Sometimes it's clear, it's black and white. Other times the lines blur a little, and it calls on analysis, discussion, and your best guess. Ethics rules are not always intuitive. And as you're going to see in a little bit, they can change over time. So what might have been true, how many here have been practicing law since before 2009? Well, what was true when you took ethics in law school may no longer be true on this particular topic. But we're going to talk about that later. The American Bar Association has been really instrumental in developing and changing ethics codes. And so, for example, in 1908, they adopted what's called the Canons of Professional Ethics, and states were free to sign on to those or not sign on to them as they saw fit. And in 1969, they adopted the Code of Professional Responsibility. And New York did sign on to that. They developed a version that was fairly similar to the model code developed by the ABA. And it had to do, if you remember, it had to do with ethical considerations, EC, and then disciplinary rules, DR. And the ethical considerations were what we were to aspire to. That was the aspirational goal, is to reach that level. Disciplinary rules were no. You must comply with this rule or you could be disciplined. And ABA considered it somewhat clunky. The ethical considerations, well, what force did those have? And so they developed, it wasn't too very long when they developed the model rules of professional conduct. It was 1983, so you can see 69 to 83 was only 14 years. And states started adopting versions of the model rules. But New York hung out. New York was the last state to abandon the model code for the model rules. And they did it in 2009. And we used to do these presentations. We were able to look like, on a national level, we'd have all of the states here and then New York over here. But for all intents and purposes, the code's now defunct. For the most part, lawyers' obligations didn't change a whole lot, though, from the code to the rules, except in the area that we're going to talk about today. It's dramatically different in some regards than what we all learned when we were in law school, and that's why we thought this was an important topic. So with that, I'm going to hand it back to Jim.
Okay, thanks, Diana. As we get involved in our discussion, because I do want you to jump in as we go along, I just know from looking around and asking a couple of questions of Gail in terms of the staff here at VLP, we've got people who practice or have practiced on an administrative level of Medicaid, special education, Social Security, SSI, unemployment, on the court level, family court, housing court, various state courts and federal court, and probably some I haven't thought about. And these rules are going to be the same in each of those settings. But you're going to see as we go through this, if there's a particular rule that governs the practice, say in family court, and Dinah is going to have an example of that later, you've got to look at the ethics rules and any evidence disclosure rules kind of in tandem to try to figure out what the answers are. If you're following along on the handout, we're on page 4, and the first thing I want to talk about is Rule 1.6, and it's very basic to the legal practice, and it's something that tends to come up the first day on the job if you've never worked in a law office before. Anything that you learn in the attorney-client relationship, and that extends to the paralegal or advocate-client relationship because you're working under the supervision of an attorney, the things you learn are sacred. Those are the client confidences. And so, and you're going to please bear with me as I'm going to be doing a bit of reading as we go through some of these rules. So 1.6a, a lawyer shall not knowingly reveal confidential information, blah, 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 unless the client gives informed consent as defined in one of the other rules. The disclosure is impliedly authorized to advance the best interests of the clients, etc., or the disclosure is permitted by Rule B. So anytime we look at, because we're going to be talking about unfavorable information, we always start out from the framework that unless there's something that kind of overrules this, anything you learn in the attorney-client relationship is sacred under Rule 1.6. And that should be nothing new. Okay? So, let's flip over to the next page and look at B, near the top of page 5. So here's the exception. A lawyer may, and you may want to highlight that word may, a lawyer may reveal or use confidential information to the extent that the lawyer reasonably believes necessary to prevent reasonably certain death or substantial bodily harm. And Keith Morgenheim will remember a day when he and I had a telephone conference with a fairly noted psychologist, trying to determine whether something that one of our clients said in the heat of activity was an indication that somebody was about to have result in substantial bodily harm or worse. And I believe in that context Diana helped us look at this rule, and it's still permissive, not mandatory. Okay? And that's a tough position to be in, to decide whether you sell out your client or put somebody at risk. And that's just going to have to always be a case-by-case judgment. The second one, if the lawyer reasonably believes necessary to prevent the client from committing a crime. And again, it's not mandatory, but it's permitted. Okay? And then you've got a number of things here, much of which I'll leave to your reading. But just keep in mind, this is an exception to those normal disclosure rules. We had, just to contrast with the one where Keith and I did not disclose, we did not report it to the police. We had a fairly recent episode within the last couple of years in our office where somebody left a voicemail on somebody's phone where we had declined service, but the person, I would say, was already a client of the office. They had entered into a relationship where these ethical rules applied. But in essence, and I won't go through all the details, it said, watch your back. Okay? It was much more descriptive than that, including a quote that apparently came out of some movie. Our executive director and I met. I think Keith joined the meeting at one point, and we decided, number one, that we were permitted to disclose and really ought to disclose, and brought in the police. But if you look at Rule 1.6b, I don't think we were required to disclose. Okay? So it does, for better or worse, give the attorney or law office a bit of discretion. Now, moving on, and this is where we get into the tension. We've got Rule 3.3, which requires candor toward the tribunal. And what do we mean by tribunal? There's a lot of stuff where we're not really going back to the definition sections to define the terms. Clearly it means a court, something before a magistrate, let's say, or referee. Administrative hearings before an administrative law judge or hearing officer, But it also includes what the rules refer to as ancillary proceedings, like a deposition or EBT, examination before trial. So what's the rule? A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. 2, fail to disclose controlling legal authority known to the lawyer. 3, offer to use evidence that the lawyer knows to be false. You're going to see this concept of knows to be, because, you know, a lawyer can't be held to know everything. If a lawyer, the lawyer's client or witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures. Reasonable remedial measures.
Jim?
Yes.
I think it's important too that it says it says you can't offer or use evidence. So even if the evidence was we're a subsequent attorney and we find out that
Yes.
that lawyer before us offered false evidence, we can't use that evidence.
For example, this could come into we've got a couple of attorneys here that do the SSI and Social Security advocacy. If you received a file from somebody else, somebody outside the office did the hearing, but you later learn that some of the evidence in that hearing file would fit into this, you know it to be false, you may have an obligation to pursue some kind of remedial measures. And that's setting aside whatever the normal Social Security hearing rules may be. Now, skipping down to C here in the middle of the page, the duties stated in paragraphs A and B apply even if compliance requires disclosure of information otherwise protected by Rule 1.6. So, if the lies, so to speak, are bad enough and clear enough, Rules 1.6 is not a safe haven to say I can sit and do nothing. Okay. D refers to the ex parte proceeding, and if it's an ex parte proceeding, like you're going to, with an order to show cause, to seek a temporary restraining order, and your adversary has not been put on notice and is not there, you have a special obligation to present all material facts. And Dinah and I have batted a lot of these issues around, and even where you're seeking a temporary restraining order, typically it's considered good practice because the judge is going to ask to put the other side on notice. If the other side is on notice, you may not have this special obligation. Questions or thoughts about any of this stuff so far? Okay. What if you're in an administrative hearing where the other side typically does not show up? This is true for a lot of our Medicaid hearings. I know in the Social Security SSI context, the Social Security Administration is not typically there to defend its decision. Are those ex parte proceedings? What do you think? I see a head going, no. Those are
usually they waive their appearance and they put an appearance in on papers only, so I don't think it's ex parte.
Yeah, what Karen said is, and this is certainly true in the Medicaid context, usually they put their appearance in on papers and waive their right to appear. The point is they could have appeared, they were on notice. In the Social Security context, they've set up the hearings in such a way that they don't show up. So I don't think these are bound by those rules that you have to bring everything forward. And that's going to become important as we look at this obligation. Skipping down a little bit more to large B here near the bottom of page 6. With any one of these rules, they're always followed by comments, which kind of further explain what they really mean. So the comments to Rule 3.3 help clarify the ethical obligations. Comment 1. I mentioned, it's extended to any of those ancillary proceedings like a deposition. Comment 2, in talking about the advocate's duty to candor to the tribunal, the second sentence, as an officer of the court, lawyers are required to avoid conduct which undermines the integrity of the adjudicative process. One of the challenges when you read these things is there is usually something countervailing, and I'm not finding it quickly here, but I know I've got it highlighted. There's a recognition here that when both sides are represented, it's not your job to bring everything forward. There's an acknowledgement that you're going to present the side of the case that's most beneficial to your client, and it's the other side who's going to find that adverse evidence. Obviously, though, that's always going to be contextual. And just on page 7, I'm just going to highlight a few more of these. Comment 5, lawyer must not offer or use evidence the lawyer knows to be false, regardless of the client's wishes. Comment 8 establishes that a prohibition applies only if the lawyer knows that the evidence is false. And you certainly have the right, I might say, duty as a lawyer to err on the side of believing your client if you have no clear path otherwise. According to number 7 here, according to comment 9, while a lawyer must not offer evidence the lawyer knows to be false, the lawyer may refuse to offer evidence the lawyer reasonably believes to be false. Comment 10 and number 8 here, one sentence down, the lawyer must take remedial measure. And they suggest that you always start out by having a conversation with your client to say, look, here's where we are. We need to do something about this. But ultimately, the obligation becomes you need to fix it. And we'll talk, particularly as we get into the hypothetical, what that means. Okay, here it is on page 8, under 11. Comment 14 recognizes the lawyer normally has the responsibility to present only one side of the matter because opposing counsel will present the other position. We're going to, particularly as we get into the hypothetical, address what we think is the black and white of things. But as you can see, a lot of this is going to be gray and case by case. So, Diana?
Okay, thanks.
And I don't know how I managed to bring that up again.
I don't know. I thought you wanted it up.
Diana, before we start, can you do code 1? Code 1 is ethics 101 NLS. Code 1 is ethics 101 NLS.
Okay, just so that you can pick that up, the code is ethics 101 NLS.
Thank you.
If you're watching this on video, you'll need that code if you want the credit, I assume. Okay, page 8. The obligations under 3.3 are significantly different than they were under the Code of Professional Responsibility. There was one writer who said that, I'm not sure I have the exact wording here. Oh yes, it represents perhaps the most radical break with the existing code. I had a case about 15 years ago, 20 years ago in family court. It was a child support proceeding. And my client was on the stand testifying, and she said something, and I was paying attention, and I said, that's not what she's told me before. I think she's lying. So I stopped the proceeding, because this is what I'd been taught to do in law school. Stop the proceeding. Your Honor, may I speak to my client outside? Took her outside the courtroom, and I said, I think you just lied. And she said, yes. I said, well, you have to correct that. I can't participate in that. Clearly, I can't help you commit perjury. And and she says, no, I'm not going to do it. And I said, well, then I think, you have two choices. I either go in and withdraw as your attorney, or you discharge me, you fire me, which I think would bring up a lot less questions. So you're probably better off firing me than if I have to go in and ask to withdraw. And she says, okay. So we walked in, and I said, Mr. Amon, I've just been fired. And he said, okay, thank you. So I think he knew my client had just lied because it was pretty out there. And I laughed, and that was fine. But under today's rules, can't do that. I have to take remedial action, even if that means disclosing that confidential communication, which is, I lied. You know, your client tells you one thing, and then she says, well, I lied. That's confidential. Let's go just to page 4 real quickly, because I want to read the definition of confidential information under client confidences in the New York's rules. The very bottom of the page. It consists of information gained during or related to representation of a client, whatever its source, that is protected by the attorney-client privilege, likely to be embarrassing or detrimental to the client if disclosed, or information that the client has requested be kept confidential. So if your client tells you I lied, and she tells you that in the confidential communication, it fits the definition. It's embarrassing, it could be detrimental, they could theoretically be arrested and tried for perjury, it would go against your case. So there was an ethics opinion decided by New York County lawyers in 1996. Opinion number 712. And it was decided under the old code. And they clarified that if a lawyer who is later told by the client that material facts in his deposition are not true may not disclose that information. May not. He must urge his client to correct. Failing that, he must withdraw. So I did exactly what they said I was to do under the code. In, I'm not sure what year it was decided. I think it was 2010. Under the rules, opinion from the same Bar Association, opinion number 741, they specifically withdrew that opinion, 712, and said no longer. The duty has changed. You must now take remedial action, remedial measures to correct the falsehood. Withdrawing is not sufficient, as the counsel. Interestingly, and this is the first time that ever came up, that opinion also did decline to comment on the impact of CPLR Section 4503. Now, you might say, what is CPLR Section 4503? Well, it's the section of law that defines the attorney-client privilege. And that section states, unless the client waives the privilege, so whose privilege is it? Client's. An attorney or his or her employee shall not disclose or be allowed to disclose such confidential communication, nor shall the client be compelled to disclose such communication. So you have a section out there in the CPLR that sets up a privilege that protects confidential communication. And what the ethics opinion has stated is we're not going to talk about what impact that has on your ethical obligation to take remedial action. So you, now, granted, privileges are an evidentiary issue. So, you know, the 4503 would prevent the attorney from testifying to the confidential communication. So you could not be required to reveal that your client told you they lied in the deposition. But does that save you from revealing that your client lied in order to correct the record? And I'm not sure that, I think the jury's out on that. I have not found anything that really clarifies what trumps. There is a later ethics opinion. It's ethics opinion, I think 837 from 2010 that said that CPLR 4503 limits the scope of remedial measures, but only protects confidential communications from being introduced into evidence. So So when you're factoring in what your legal obligation is, you have to also decide, where is this going to go? Is it gonna result in evidence that is confidential, in which case it's my client's privilege. I can't waive it, only the client can waive it. And what has priority?
Diana, can I get you to take a 2-minute pause? Just say
Yes.
we're gonna take a 2-minute pause.
We're gonna take a 2-minute pause. Station identification.